Masterpiece Cakeshop versus Colorado Civil Rights Commission, 2018. The facts of the case are as follows. In July of 2012, Charlie Craig and David Mullins went to Masterpiece Cakeshop in Lakewood, Colorado, and requested that its owner, Jack Phillips, design and create a cake for their wedding. Phillips declined to do so on the grounds that he does not create wedding cakes for same-sex weddings because of his religious beliefs. Phillips believes that decorating cakes is a form of art through which he can honor God, and that it would displease God to create cakes for same-sex marriages. Craig and Mullins filed charges of discrimination with the Colorado Civil Rights Division, alleging discrimination on based on sexual orientation under the Colorado Anti-Discrimination Act. And after the division issued a notice of determination finding probable cause, Craig and Mullins filed a formal complaint with the Office of Administrative Courts, alleging that Masterpiece discriminated against them in a place of public accommodation in violation of CADA. So, the administrative law judge issued a written order finding in favor of Craig and Mullins, which was affirmed by the Colorado Civil Rights Commission. On appeal, the Colorado Court of Appeals subsequently affirmed the Commission's ruling. The question in this case is, does the application of Colorado's public accommodations law to compel a cake maker to design and make a cake that violates his sincerely held religious beliefs about same-sex marriage violate the free speech or the free exercise clause of the First Amendment? The court addressed this case based on the free exercise, not the free speech clause. Speaking for the court, Justice Kennedy, in a 7-2 decision, held that Civil Rights Commission's conduct in evaluating a cake shop owner's reasons for declining to make a wedding cake for the same-sex couple violated the free exercise clause. The court explained that while gay persons and same-sex couples are afforded civil rights protections under the laws and the Constitution, religious and philosophical objections to same-sex marriage are protected views and can also be protected forms of expression. The Colorado law at issue in this case, which prohibited discrimination against gay people in purchasing products and services, had to be applied in a neutral manner with regard to religion. The majority acknowledged that, from Phillips's perspective, creating cakes was a form of artistic expression and a component of his sincere religious beliefs. So what are the consequences of this case? The Supreme Court did not answer the substantive question at hand. That is, can a business owner refuse to provide a particular product or service to the public because of his or her religious beliefs? The case was decided on narrow procedural grounds. The Colorado Civil Rights Commission did not use formally neutral standard when examining Jack Phillips's religious beliefs. Instead, the Colorado Civil Rights Commission compared his beliefs to defense of slavery and the Holocaust, and the majority on the Supreme Court found this unacceptable. The very same Colorado law would be tested again in a similar case called 303 Creative versus Elenis, and decided in favor of the business owner, but based on freedom of speech, that is to say, using the free speech clause, and not freedom of religion, not using the free exercise clause. So we see here that the court is reluctant to address the substantive issue. Can religion get you out of your responsibility to serve customers based on your specific religious beliefs? And we see that it was left up to 303 Creative versus Elenis based on the free speech clause, to basically say that the owner, as long as he or she has engaged in sincere expression, that justifies essentially an exemption from the law, or from this particular application of the law, where you have to provide a particular service. So the free exercise clause substantively turned out to be no help to such business owners, but the free speech clause in fact, proved to be such help in 2023 in the case 303 Creative versus Elenis. Thank you.